How to amend the Constitution? By constitutional amendment, we mean making correction or changes or revisions in the provisions of the Constitution. The Constitution should be amended if so required, but it should be protected from unnecessary and frequent changes. In other words, the Constitution should be flexible and rigid at the same time. Constitutions which are open to changes are called flexible constitutions. Such constitutions can be easily changed or modified. Rigid constitutions resist changes. They are very difficult to amend. Indian Constitution combines both these characteristics. It is rigid as well as flexible. The makers of the Constitution were aware of the fact that there may be some mistakes in the Constitution. They knew that the Constitution could not be totally free of errors. So they wanted the Constitution to be easily amended to get rid of these errors where they come to notice. There were certain provisions in the Constitution which were of temporary nature. It was decided by the framers of the Constitution that such provisions could be amended after the formation of the new parliament. The Constitution was framing a federal polity. Therefore, the rights and powers of the states could not be changed without the consent of the states. Apart from these, the makers of the Constitution were anxious to protect some features which were central to the spirit of the Constitution. They wanted to protect them from amendments. So they decided to make these provisions rigid. These considerations really led to the adoption of different ways of Constitution amendments. Procedure for the amendment of Constitution. By constitutional amendment, we mean the procedure such as an addition of a new provision or a change in any article or a repeal of any provision within the original Constitution. It is not a total change of the Constitution. The power to make amendments in the Indian Constitution is vested in the Parliament. For making amendments, the Parliament functions as the Constituent Assembly and makes necessary changes in the Constitution. In order to make amendments, the articles of the Constitution are classified into three categories. The first category of articles can be amended by the simple majority of Parliament. The procedure to amend the second and third category of articles is outlined in the Article 368 of the Constitution. This article states that special majority of the Parliament is necessary for amending the second and third category of articles. There are two types of special majority. For amending the second category of articles, two-thirds majority of members present and vote in both houses separately is necessary. For amending the third category of articles, the special majority of Parliament and the ratification by not less than half of the total state legislatures is required. In short, there are three types of constitution amendments. 1. Amendments by simple majority in Parliament. 2. Amendments by special majority in both houses of Parliament separately in. 3. Amendments by special majority plus ratification of half of the state legislatures. 1. Amendment with simple majority of Parliament. Certain provisions of the Constitution can be amended with the simple majority of Parliament. They can be changed by a simple law of Parliament. No special procedure is required for such amendments. Here, there is no difference between a constitutional law and an ordinary law. This part of the Constitution which can be amended by Parliament with simple majority is really flexible. The bill for amending the Constitution can be presented in either House of Parliament. When both Houses of Parliament pass the bill with simple majority, it can be presented to the President for his assent. When President gives assent to the bill, amendment of the Constitution comes into force. The following are some of the subjects which can be amended by Parliament with simple majority. Provisions regarding the change of name and boundaries of new states. Provisions for the formation of states. Provisions for creation or abolition of legislative councils in states. 1, 4, 5 and 6 schedules of the Constitution. Provisions regarding citizenship. 2. Amendment by two-thirds majority of Parliament. Amendment of the second category of articles can be made by special majority of the two houses of the Parliament. According to this method, an amendment bill can be passed only if it gets the ratification of two-thirds majority of members present and vote in both houses of Parliament. If passed, the amendment bill can be submitted to the President for his assent. The amendment comes into effect when it gets the assent of President. The article in Part 3 and IB of the Constitution can be amended through this procedure. 3. Amendments made by special majority of Parliament with the ratification of states. In order to amend the articles in the third category, the amendment bill should be passed by a special majority of Parliament. Then it should be ratified by not less than half of the state legislatures. If the bill gets the support of the special majority of Parliament and at least half of the state legislatures, it can be presented to the President for his assent. When it gets the approval of President, it comes into effect. Compared to other methods of amendment, this method is more difficult. Provisions regarding the election of the President, division of powers between the center and state, Supreme Court and High Courts, representation of states in Parliament and amendment of the Constitution can be changed only by following the procedure. It is already mentioned that the power to amend the Constitution is vested in the Parliament. Like all other bills, an amendment bill, if it is passed by the Parliament, goes to the President for his assent. But President has no right to send it back to the Parliament for reconsideration. Thus the Constitution avoids all complications in the process of amendment. Moreover, it makes the amendment procedure simpler.